The courtroom erupted in laughter when 9-year-old Elijah Jackson stood up in the Richmond County Courthouse. Nobody expected what happened next. Judge Pearson's smirk vanished as Elijah cited legal precedent that silenced the room. His mother wiped away tears while the wealthy landlord's attorney frantically shuffled papers. Before we dive into this incredible story of courage and justice, let me know where you're watching from in the comments. If this kind of triumph against all odds inspires you, smash that like button and subscribe to see more stories of extraordinary people fighting injustice. Now let's rewind to see how a 9-year-old boy became an unexpected legal champion for his mother and his entire community. The morning sun filtered through thin curtains in apartment 4B of Oakwood Heights, a once affordable housing complex in Richmond, Virginia. Elijah Jackson sat at the small kitchen table, his textbooks spread around him as he finished his homework before school. At 9 years old, his intelligence already outpaced many of his teachers, though few bothered to notice. His mother, Denise Jackson, rushed around their modest 2-bedroom apartment, gathering her things for the first of her 3 jobs. "Don't forget your science project," she reminded him, pouring coffee into a travel mug, "and Mrs. Wilson will pick you up for the after-school program." Denise worked morning shifts at Memorial Hospital's cafeteria, afternoons as a receptionist at Bright Smile Dental, and evenings taking customer service calls remotely from their apartment. The schedule was grueling, but it kept a roof over their heads and food on the table. Elijah nodded without looking up from his book, already engrossed in material far beyond his grade level. While other third-graders struggled with basic chapter books, Elijah devoured college-level texts on history, science, and increasingly, law. Their apartment was small but meticulously kept. Photos of Elijah's father, Sergeant Marcus Jackson, adorned the walls and shelves. He had died in military service overseas when Elijah was just 4 years old. The boy often found himself staring at those photos, trying to keep the fading memories of his father alive. One photo in particular, Marcus in his dress uniform with his arm around a pregnant Denise, held a special place above Elijah's bed. Oakwood Heights had once been a thriving community of working-class families, predominantly black and immigrant households striving for better lives. But in recent months, things had begun to change. Westfield Development Group, owned by Maxwell Barrett, a wealthy white developer with political connections throughout Richmond, had purchased the property and several surrounding blocks. Barrett's vision involved demolishing the existing structures to make way for Riverview Commons, luxury condominiums, with rents triple what current residents paid. The tension in the neighborhood grew palpable as construction equipment appeared on nearby lots. Strange things started happening at Oakwood Heights. The heating system failed during a cold snap, leaving families shivering for days before minimal repairs were made. Water leaks appeared in ceilings, damaging personal belongings. Cockroach and rat infestations went untreated despite repeated complaints to the management office. Maintenance requests from black and immigrant tenants were consistently lost or delayed, while the few remaining white tenants received prompt service. Elijah noticed the pattern before his mother did. He kept a small notebook where he documented dates, times, and responses to various tenant issues. One evening, Denise invited several neighbors to their apartment to discuss the deteriorating conditions. Mrs. Gladys Coleman, an elderly retired school librarian who lived on the first floor, brought homemade sweet potato pie. The Rodriguez family from 3C brought concerns about mold growing in their bathroom that management refused to address. The Okonkwo family from 5 Amperes described receiving noise complaints for their traditional family gathering, despite the building having hosted much louder parties from other residents without issue. What no one noticed was Barrett's property manager, Vincent Keller, photographing everyone who entered the Jackson apartment from his car across the street. The next morning, Denise was running late for her hospital shift when she noticed the white envelope taped to their door. Her hands trembled as she read the official-looking notice inside. Eviction notice. The document claimed multiple lease violations, including excessive noise, unauthorized occupants, and property damage, all completely fabricated. They had 30 days to vacate. When Elijah returned from school that afternoon, he found his mother sitting on the couch, her eyes red from crying, the crumpled eviction notice on the coffee table. "Mom, what's wrong?" he asked, his backpack sliding to the floor. Denise quickly wiped her eyes. "It's adult stuff, baby. Nothing for you to worry about." But Elijah picked up the notice, his young eyes rapidly scanning the legal jargon. "They're lying," he said quietly. "We didn't do any of these things." Denise pulled him close. "I know that. But fighting people like Barrett takes money we don't have. They have lawyers. They have judges in their pockets." Elijah's jaw set in determination. "I'll help you fight them." Denise gave a sad smile, ruffling his tight curls. "That's sweet, honey, but this is something adults need to handle." Later that evening, Elijah slipped next door to visit Mrs. Coleman. The elderly woman had become something of a mentor to him, encouraging his advanced reading and critical thinking. Her apartment smelled of lavender and old books, and her walls were lined with photographs from her 50 years as a librarian. "They're coming for all of us," she told Elijah, showing him her own eviction notice with identical false claims. "Barrett wants us gone so he can build his luxury condos. He thinks we're too poor and too black to fight back." Elijah sat quietly, absorbing her words. Just as he was about to respond, his mother's phone buzzed with a text from another neighbor. "They're coming for all of us. Emergency tenant meeting tomorrow night." Looking at Mrs. Coleman's worried face and thinking of his mother's tears, Elijah made a silent promise. He would find a way to fight back. He just needed to figure out how. The Richmond Public Library stood like a sanctuary of knowledge, its brick facade and wide steps welcoming visitors into its quiet halls. For Elijah Jackson, it became a second home in the weeks following the eviction notice. Instead of attending his after-school program at Oakwood Community Center, Elijah told Mrs. Wilson he had joined a special study group. In reality, he spent those precious afternoon hours in the library's legal section, pulling heavy volumes that dwarfed his small frame. On his third visit, the librarian Miss Rodriguez approached his table with curiosity. "That's some heavy reading for someone your age," she observed, glancing at the Virginia Housing Code manual open before him. "School project?" Elijah hesitated, then decided on honesty. "My mom got an eviction notice. The landlord lied about violations. I want to help her." Instead of dismissing him, Miss Rodriguez studied his serious expression and nodded. "Legal research requires organization. Let me show you how to find exactly what you need." Under her guidance, Elijah learned to navigate legal databases, housing regulations, and court precedents. She helped him create a system using color-coded notebooks: blue for housing laws, green for tenant rights, red for discrimination cases, yellow for procedural rules. The notebooks rapidly filled with Elijah's neat handwriting, diagrams, and sticky notes marking important passages. His motivation went beyond the immediate eviction threat. Memories of past injustices fueled his determination. Last semester, his English teacher, Mrs. Brubaker, had questioned his book report on To Kill a Mockingbird, suggesting the analysis was too sophisticated for a third grader. "These insights seem unusual for kids from your neighborhood," she had said with thinly veiled skepticism, implying he had plagiarized the work. When his standardized test scores came back in the 99th percentile, Principal Whitmore had insisted Elijah retake the exam under supervision, something never required of white students with high scores. The principal's surprise at his second perfect score felt more insulting than validating. These experiences hardened Elijah's resolve to master knowledge no one expected him to have. As days turned into weeks, Elijah discovered disturbing patterns in Barrett's business practices. Eviction notices had been served exclusively to black families, Hispanic residents, and the few Southeast Asian households in Oakwood Heights. Not a single white tenant had received one, despite similar family sizes and rental histories. He created a wall of documentation in his bedroom closet, hidden behind hanging clothes. Index cards connected with string mapped the relationships between Barrett, local officials, and previous housing developments where similar patterns emerged. One afternoon, Elijah noticed a young black man in the library repeatedly using the legal databases. Gathering his courage, he approached. "Excuse me, are you a lawyer?" The man laughed. "Not yet. Anthony Williamson, second-year paralegal student at Richmond Community College." When Elijah explained his situation, Anthony was impressed by the boy's research. You've done more homework than most of my classmates. Look, I can't give legal advice, but I can show you how court procedures work. Anthony became an invaluable resource, explaining filing procedures, courtroom protocols, and the proper way to present evidence. He helped Elijah understand complex legal terminology and the hierarchy of housing regulations from federal down to local ordinances. Through Anthony's student account, Elijah discovered Barrett's company had faced discrimination complaints in 3 other cities, each time settling quietly while admitting no wrongdoing. The settlements included non-disclosure agreements that prevented victims from discussing their cases publicly. Most crucially, Elijah learned about class action lawsuits and housing discrimination precedents that could potentially help not just his mother, but all the targeted families at Oakwood Heights. During a Saturday visit to Mrs. Coleman, Elijah carefully recorded her experiences with maintenance requests. 6 times I reported my broken heater in January, she confirmed, showing him carbon copies of maintenance forms. The White family in 2 Amperes had theirs fixed the same day they called. She introduced Elijah to other residents who shared similar stories, ignoring repair requests, falsely claiming tenants weren't home during scheduled maintenance visits, and performing shoddy repairs that created new problems. Each conversation added to Elijah's growing documentation. His breakthrough came when Anthony helped him file a Freedom of Information Act request for Barrett's permit applications. Among the documents was an internal memo accidentally included in the public records. It detailed a demographic adjustment strategy for Oakwood Heights, explicitly discussing ways to remove less desirable elements to improve the neighborhood profile. The language thinly veiled its racist intent, referring to culture matching and lifestyle compatibility with future luxury tenants. Elijah's hands shook with a mixture of anger and vindication as he carefully photocopied the memo. The smoking gun was finally in his possession. Returning home late that evening, Elijah found his mother waiting with arms crossed, her expression a mixture of worry and disappointment. Mrs. Wilson called. "You haven't been at the after-school program for weeks. Where have you been, Elijah?" Before he could answer, Denise noticed the stack of legal books and notebooks. Confused, she followed Elijah to his bedroom, where he reluctantly slid open his closet door, revealing the extensive research wall he had created. Newspaper clippings, property records, maintenance request copies, legal citations, and the map of Barrett's connections covered the wall from floor to ceiling. In the center was the eviction notice with red marker circling the false claims. Denise's hand covered her mouth as she took in the scope of her son's secret work. "Oh, Elijah," she whispered, "what have you been doing? What happens when the system designed to protect citizens becomes the very mechanism used to crush them?" As Denise Jackson stared at her son's meticulous research wall, her initial shock gave way to a complex mixture of pride and fear. Pride in Elijah's extraordinary intellect and determination. Fear about the powerful forces they were up against. "This is amazing work, baby," she told him, examining the detailed notes. "But these people have money and influence. Sometimes fighting just makes things worse." Despite her concerns, Denise decided to pursue official channels to contest the eviction. The next morning, she called in sick to her hospital job and visited the Richmond Legal Aid Society. After waiting 3 hours in a crowded office with peeling paint and outdated magazines, she finally met with an overworked attorney named Greg Phillips. He reviewed her eviction notice with weary eyes. "Unfortunately, we're backlogged 6 months with cases," he explained. "By then, your eviction will be long completed. I can give you some self-help pamphlets, but that's all we can offer right now." The pamphlets, Elijah noted later, contained less information than he'd gathered in his first day of research. Denise next contacted the Richmond Housing Authority. The receptionist transferred her call 4 times before she reached Brenda Miller, a housing compliance officer. "We can't intervene in private landlord-tenant disputes until they've gone through proper court procedures," Miller informed her. "File a formal complaint after your court date, and we'll review it within our standard 90-day window." The circular logic wasn't lost on Denise. By then, they would already be homeless. Meanwhile, Barrett's company accelerated the eviction timeline, claiming newly discovered safety concerns in the building required immediate action. The 30-day notice shrunk to 14 days. When Denise visited the property management office to discuss the shortened timeline, Vincent Keller received her with a cold smile that never reached his eyes. "Mrs. Jackson, the concerns about your tenancy have been documented extensively," he said, gesturing to a folder he deliberately kept closed. "Perhaps you should consider this an opportunity to find housing more appropriate for your situation." When Denise pressed for specifics about the alleged violations, Keller leaned forward, his voice dropping. "Look, people like you should know their place. This neighborhood is changing. You can make this difficult, or you can accept the inevitable." The thinly veiled racism in his tone made his meaning unmistakable. The court date was scheduled for the following Tuesday, with Judge Harold Pearson presiding. Elijah immediately recognized the name from his research. Pearson had served on the board of the Richmond Business Development Association alongside Maxwell Barrett 3 years earlier. Their connection ran deeper than professional courtesy. They were golf buddies at the exclusive Hillcrest Country Club, where membership remained predominantly white despite discrimination lawsuits. "I need to come to court with you," Elijah insisted at breakfast the morning before the hearing. Denise shook her head firmly. "Absolutely not. It's a school day, and this isn't a place for children." Elijah pushed his cereal bowl away. "Mom, I've studied everything about our case. I know things the lawyer at Legal Aid didn't even mention." After 30 minutes of debate, Denise reluctantly agreed, recognizing her son's preparation might actually help their case. That evening, several families from Oakwood Heights gathered in the community room to discuss their identical situations. Shanice Taylor, a community activist known for her work with housing justice organizations, had agreed to attend. "What Barrett's doing is textbook predatory development," she explained to the group. "They create uninhabitable conditions, manufacture lease violations, then push out long-term tenants to rebuild for wealthy newcomers." She suggested contacting local news outlets, but Luis Rodriguez, whose family had lived in Oakwood for 15 years, shared discouraging news. "I already tried Channel 4 News. They seemed interested until Barrett's company threatened to pull advertising. Suddenly, they decided it wasn't newsworthy." The pattern repeated across local media: initial interest followed by mysterious editorial decisions to pursue other stories. With legal aid unavailable and the media silenced, the tenants felt increasingly hopeless. Denise couldn't afford a private attorney. Medical bills from her hospitalization the previous year had depleted her modest savings, and her 3 jobs barely covered current expenses. While the adults discussed limited options, Elijah continued his research. Through public records, he discovered Judge Pearson had received campaign contributions from Barrett's development company during his judicial election. More troublingly, Pearson's brother-in-law worked as a contractor on several Barrett properties. These connections represented clear conflicts of interest that should have disqualified Pearson from hearing any cases involving Barrett's companies. The following day brought another blow. Denise received a call from Dr. Morrison at Bright Smile Dental, informing her that her receptionist position was being eliminated due to restructuring. When pressed, he admitted receiving a complaint about her but refused to provide details. With 1/3 of their income suddenly gone, the threat of homelessness loomed even larger. That night, Elijah overheard his mother on the phone with his aunt in Baltimore, asking if they could stay temporarily if the eviction proceeded. The desperation in her voice strengthened his resolve. While Denise slept, Elijah called the courthouse using the voice-changing app he had downloaded to his mother's old phone. Pretending to be a paralegal researching procedural questions, he gathered valuable information about Judge Pearson's courtroom protocols and scheduling practices. "Do you believe a system that's supposed to protect citizens should be allowed to operate with such obvious conflicts of interest?" Comment number 1. If you think judges with financial connections to developers should be allowed to preside over eviction cases. Or comment number 2, if you think they should be required to recuse themselves. Hit that like button if you believe 9-year-old Elijah is showing more integrity than the adults in power. And subscribe if you want to see how this young legal genius prepares for the courtroom battle of his life. How will Elijah use his self-taught legal knowledge when facing a biased judge and a powerful developer? What strategy could possibly save his mother and their neighbors from unjust eviction? The Richmond County Courthouse loomed before them, its neoclassical columns and stone steps projecting an aura of authority and tradition. Denise Jackson clutched her folder of documents in one hand, and Elijah's small shoulder in the other as they climbed toward the imposing entrance. Inside, the cavernous main hall echoed with footsteps and hushed conversations. A directory board directed them to courtroom 4B for housing court proceedings. The wooden benches in the courtroom were already filled with anxious tenants, mostly black and brown faces wearing their best clothes, many taking unpaid time off work to fight for their homes. Elijah immediately noted the stark contrast between their side of the room and the area occupied by Maxwell Barrett's legal team. 3 attorneys in tailored suits arranged documents on their table, their leather briefcases alone probably costing more than a month's rent at Oakwood Heights. Barrett himself sat behind them, scrolling through his phone with apparent boredom, his crisp navy suit and gold watch showcasing the wealth disparity at the heart of the proceedings. Mrs. Coleman waved them over to a saved seat. Other familiar faces from Oakwood nodded in silent solidarity. The tension in the room was palpable, the power imbalance obvious to everyone. "All rise for the Honorable Judge Harold Pearson," the bailiff announced. Judge Pearson entered, his jowly face set in a practiced expression of judicial neutrality that didn't quite mask the dismissive glance he cast toward the tenant section. The morning proceeded with mechanical efficiency, as case after case resulted in victory for landlords. Each tenant was given minimal time to speak before being interrupted with legal terminology and procedural objections. By the time the bailiff called Jackson v. Westfield Development Group, Elijah had counted 17 consecutive rulings favoring property owners, many represented by the same attorneys now facing his mother. Denise approached the podium, her voice steady despite her nerves. "Your Honor, the claims against me are completely false. I've never violated my lease in 5 years of tenancy." Judge Pearson peered over his glasses. "Do you have evidence to support your claim, Mrs. Jackson?" Before she could respond, the lead attorney for Barrett's company, Thomas Whitmore, stood. "Your Honor, if I may, we have substantial documentation of repeated violations." He approached the bench with a folder containing photographs allegedly showing damage to the Jackson apartment. Elijah recognized them immediately. The photos had been doctored to show stains, holes, and damage that simply didn't exist in their meticulously maintained home. Whitmore continued, his voice dripping with rehearsed concern. "Additionally, we've received multiple noise complaints from surrounding tenants. Mrs. Jackson regularly hosts large gatherings that disturb other residents. This was another complete fabrication." Denise worked evenings and weekends. She barely had time for the occasional small dinner with family, let alone parties. When Denise attempted to respond, Judge Pearson raised his hand. "Mrs. Jackson, do you have documentation disproving these claims?" Denise pulled out her phone. "I have photos of our apartment taken yesterday showing no damage." Judge Pearson frowned. Unauthenticated digital photos taken by the defendant are hardly compelling evidence. He didn't even look at the screen she held up. "Your Honor," Denise persisted, "I also have signed statements from neighbors confirming there have never been noise complaints." Whitmore interjected smoothly. "Statements from other tenants facing similar proceedings hardly constitute unbiased testimony, Your Honor." Judge Pearson nodded in agreement. "Indeed. Mrs. Jackson, do you have any other evidence to present?" Elijah watched as the same pattern from earlier cases repeated. When white landlords presented evidence, it was accepted without question. When black tenants offered counterclaims, they faced intense scrutiny and dismissal. Barrett's team made several racially coded statements, referring to certain elements in the building and the need for a higher class of tenant to revitalize the neighborhood. The implications were clear to everyone in the room. Denise attempted to introduce maintenance records, showing her repeated requests for repairs that went unanswered, but Judge Pearson waved them away. "These records aren't relevant to the lease violations in question." With each rejected piece of evidence, Denise's shoulders slumped further. Tears of frustration threatened to fall as she realized the futility of her position. The entire proceeding seemed predetermined, a performance of justice without its substance. From the gallery, Elijah watched his mother being systematically humiliated. The judge repeatedly cut her off mid-sentence while allowing Barrett's attorneys to speak at length. When she attempted to question the authenticity of the photographs, Judge Pearson admonished her for wasting the court's time with conspiracy theories. After 20 minutes of one-sided proceedings, Judge Pearson began to summarize. Based on the evidence presented, it appears clear that the lease violations are well documented. Unless you have something substantive to add, Mrs. Jackson, I'm prepared to rule. Elijah could no longer remain silent. He tugged his mother's sleeve and whispered urgently in her ear. After a moment's hesitation, she turned to the judge. Your Honor, my son has been helping me research our case. Would the court allow him to present some information? Judge Pearson's eyebrows rose in disbelief. You want your child to address this court? Several attorneys at the Barrett table exchanged amused glances. One poorly concealed a snicker behind his hand. He's very knowledgeable about our situation, Denise insisted. The judge sighed dramatically. Very well. A brief statement only. As Elijah approached the podium, a ripple of laughter spread through the courtroom. Standing on tiptoes to reach the microphone, his small frame in his Sunday best, a button-up shirt and clip-on tie that had belonged to his father, created a visual his mother would never forget. Judge Pearson made a show of checking his watch. Young man, this is a court of law, not a school presentation. Mrs. Jackson, bringing children to do adult business is inappropriate. More laughter followed, louder this time. Barrett leaned forward in his seat, apparently entertained by the spectacle. Denise felt her cheeks burn with embarrassment, but Elijah remained calm. He carefully opened the folder he carried, removing a stack of meticulously organized papers with color-coded tabs. The courtroom quieted slightly as curiosity replaced amusement. No one expected what happened next. Your Honor, I'd like to direct the court's attention to Virginia Housing Code Section 45.3, which establishes a landlord's obligation to maintain habitable premises, Elijah began, his clear voice carrying surprising authority despite his youth. Specifically, Subsection C prohibits retaliatory evictions when tenants have reported code violations. The courtroom fell silent. Judge Pearson blinked in surprise, while Barrett's attorneys exchanged uncertain glances. Thomas Whitmore's smirk faded as Elijah continued with precise legal citations. In Simmons v. Richland Properties, the Virginia Supreme Court established that the burden of proof in retaliatory eviction claims shifts to the landlord. Once a pattern of maintenance requests preceding eviction notices has been established. Elijah removed a binder from his backpack, opening it to a tabbed section. I've documented 27 maintenance requests from our apartment over the past 8 months, all with corresponding confirmation numbers and dates. He presented another document. Here's a statistical analysis of response times showing units occupied by white tenants received repairs within an average of 24 hours, while units occupied by black tenants, including ours, waited an average of 17 days for the same services. Judge Pearson frowned. Young man, where did you get these statistics? Public records request, Your Honor. The maintenance logs are required documentation for HUD-subsidized properties, which Oakwood Heights was until last year. The records remain subject to public disclosure during the transition period. One of Barrett's attorneys whispered urgently to Whitmore, who was no longer smiling. Elijah then addressed the photographs presented as evidence. Regarding the alleged apartment damage, I would like to submit these before and after comparisons. He produced side-by-side images showing the original condition of their apartment alongside the doctored photos Barrett's team had submitted. Digital forensic analysis shows these images were modified using Adobe Photoshop on March 3rd, one day before our eviction notice was issued. The metadata remains embedded in the digital file. Judge Pearson leaned forward. Where exactly did you obtain the plaintiff's evidence files? They were provided during discovery, Elijah replied smoothly, using a term he had learned from Anthony. Additionally, Your Honor, I have recorded conversations with Westfield property manager Vincent Keller explicitly stating their intent to remove certain tenants before renovation. Elijah played a brief audio clip on his mother's phone, Keller's voice saying, Barrett wants all these units empty by summer. We have ways of making the undesirables leave voluntarily. The courtroom murmured in shock. Barrett's face darkened as he whispered furiously to his legal team. Furthermore, Elijah continued, gaining confidence, I would like to cite 3 similar cases: Thompson versus Urban Development Corporation, Jackson versus Heritage Properties, and Gonzalez versus Westside Management. In all 3 cases, courts ruled against landlords who engaged in discriminatory practices disguised as lease enforcement. As Elijah spoke, the courtroom doors quietly opened. Word had spread through the courthouse about the child prodigy in housing court. Attorneys from other proceedings, courthouse staff, and curious onlookers slipped in to witness the extraordinary scene. A young black boy standing before a judge, citing case law and presenting evidence like a seasoned attorney. Barrett's team attempted to regain control. Your Honor, Whitmore interjected, this is highly irregular. These recordings, if they even exist, were obtained without consent and would be inadmissible. Elijah responded without hesitation. Virginia is a one-party consent state for recordings, Your Honor. Code Section 19.2-62.1 permits recording of conversations when one party consents. My mother was present and consenting during this interaction. Judge Pearson's expression shifted between astonishment and discomfort. Elijah wasn't finished. He produced a map of Oakwood Heights with apartments color-coded by tenant race and eviction status. Statistical analysis shows that 100% of eviction notices were issued to non-white residents, despite white residents having similar family sizes, rental histories, and in some cases, documented lease violations that were never addressed. In the gallery, a courthouse reporter who had wandered in began taking detailed notes. Barrett's attorneys huddled in urgent consultation. Judge Pearson, increasingly uncomfortable, shuffled papers before him. Young man, while this is unusual, I need to remind you that Elijah respectfully interrupted. Your Honor, I understand court procedure requires evidence to be properly submitted. That's why I've prepared this motion to introduce supplementary evidence under Rule 7.2 of the Virginia Rules of Civil Procedure. He handed a document to the bailiff, who, after a bewildered pause, delivered it to the judge. Denise watched her son with a mixture of awe and trepidation. The small boy standing before the court bore little resemblance to the child who played with Lego bricks on their living room floor. This Elijah spoke with the precision and confidence of someone 3 times his age. Judge Pearson scanned the motion, his frown deepening. Where exactly did you learn to prepare legal motions? The Richmond Public Library has extensive legal resources, Your Honor. Mrs. Rodriguez in the reference section was particularly helpful. The courtroom tittered with nervous laughter. For his finale, Elijah presented his most damning evidence. Most significantly, Your Honor, we've obtained through FOIA request an internal Westfield development memo outlining their demographic adjustment strategy for Oakwood Heights. He presented copies of the document, pointing to highlighted sections. The memo explicitly discusses removing less desirable elements to improve the neighborhood profile before luxury renovation. The document uses coded language about culture matching and lifestyle compatibility, while specifically targeting buildings with predominantly minority occupants. Barrett's face had turned a dangerous shade of red. He grabbed Whitmore's arm, whispering furiously. Judge Pearson examined the document with growing alarm. Elijah concluded by addressing legal ethics. Finally, Your Honor, I feel obligated to note that judicial ethics guidelines require disclosure of potential conflicts of interest. Public records indicate significant financial connections between Westfield Development and several parties involved in these proceedings. The implication hung in the air, unmistakable to everyone present. Judge Pearson's expression shifted from surprise to anger to something resembling fear. After a long, tense silence, he cleared his throat. This court will take a 30-minute recess to review these unusual submissions. As he rose, his eyes locked briefly with Barrett's, an unspoken communication passing between them. The courtroom buzzed with excited conversation as the judge departed. Denise pulled Elijah into a tight embrace, tears streaming down her face. "Where did you learn all this?" she whispered. Elijah smiled. "I told you I was going to help." In the gallery, Mrs. Coleman wiped proud tears while other Oakwood residents stared in amazement. Even opposing counsel appeared shaken, hurriedly reviewing the documents Elijah had presented. Barrett himself had vanished during the recess, presumably to make urgent phone calls. No one in the courtroom that day would ever forget the moment when laughter turned to stunned silence, when a child armed with nothing but library books and determination had challenged a system built to exclude people who looked like him. As the bailiff called them back to order 30 minutes later, Denise squeezed Elijah's hand. Whatever happened next, her son had already won a victory that transcended the court's eventual ruling. Have you ever witnessed the desperate measures powerful people take when their corruption is exposed? In the days following Elijah's courtroom revelation, the true nature of Maxwell Barrett and his allies emerged with frightening clarity. When court resumed after the recess, Barrett's legal team had regrouped with a new strategy. Thomas Whitmore approached the bench with manufactured concern. "Your Honor, while we appreciate the young man's enthusiasm, we have serious concerns about Mrs. Jackson's parenting decisions." He lowered his voice theatrically. What kind of mother allows her 9-year-old son to spend hours in legal research instead of engaging in age-appropriate activities? We question whether this environment constitutes proper child welfare. The implied threat was unmistakable. Judge Pearson, having recovered his composure, allowed the case to continue but with visible discomfort. He avoided looking directly at Elijah while sustaining most objections from Barrett's team and overruling those from Denise. Though he didn't dismiss the evidence Elijah had presented, he announced that further investigation would be necessary before ruling. The proceedings ended without resolution, with a follow-up hearing scheduled for 2 weeks later. Outside the courthouse, Barrett brushed past reporters with a tight smile. "No comment on ongoing litigation," he repeated while sliding into a black SUV. What seemed like a victory soon revealed itself as merely the opening salvo in a war. The anonymous call to Child Protective Services came the following morning. Denise was preparing Elijah's lunch when a knock at the door revealed 2 CPS workers, Sandra Phillips and Marcus Rivera. "We've received a report expressing concern about your son's welfare," Phillips explained, her expression professionally neutral. "Standard procedure requires us to investigate." For 2 excruciating hours, they questioned Denise about Elijah's schooling, activities, and home life. They interviewed Elijah separately, asking pointed questions about his legal research and whether his mother forced him to study instead of being a normal kid. Though they found no evidence of neglect, the invasion left Denise shaken. "This is just the beginning," Mrs. Coleman warned when Denise recounted the visit. "Barrett doesn't like losing, especially not to people he considers beneath him." Her prediction proved accurate. That evening, as Denise and Elijah walked home from the bus stop, they noticed a black sedan trailing them. The driver made no attempt to hide his actions, openly photographing them with a telephoto lens. The intimidation continued for days, the same car parked across from their building, following them to school and work. When Denise called the police, officers took a report but explained that photography in public spaces wasn't illegal. "Just someone doing their job, ma'am," one officer suggested with uncomfortable deference after glancing at the car's license plate. 3 days after the court hearing, Denise and Elijah returned home to find their apartment door slightly ajar. Inside, devastation awaited. Someone had ransacked their home, focusing particularly on Elijah's research. His carefully organized notebooks were scattered and partially destroyed. The closet wall had been stripped of its documentation, index cards torn and photos crumpled. Nothing valuable was taken. This wasn't a robbery but a message. While Denise filed another police report, receiving the same indifferent response, Elijah salvaged what he could of his materials. Thankfully, he had created digital backups of key documents on a USB drive he kept at Mrs. Coleman's apartment. The next blow came from an unexpected direction. Principal Whitmore summoned Elijah to his office the following Monday. "Your teachers report unauthorized absences from your after-school program," he began, his tone suggesting disciplinary action rather than concern. "Additionally, your recent behavior suggests you're being exposed to inappropriate adult matters." When Elijah attempted to explain, the principal cut him off. "We've received calls expressing concern about your welfare." Another incident could prompt formal intervention. The source of these concerns remained unnamed but obvious. That same afternoon, Denise received a termination letter from Memorial Hospital citing attendance issues despite her perfect record. Her supervisor, previously friendly, now avoided eye contact and referred all questions to Human Resources, who provided only vague explanations about company policy. With 2 of her 3 jobs now gone, their financial situation became dire. The retaliation extended beyond the Jackson family. Other Oakwood tenants who had supported them faced similar harassment. The Rodriguez family found their car vandalized. Mrs. Coleman's apartment experienced mysterious plumbing issues that flooded her collection of books. The Okonkwo family received noise complaints for normal daytime activities. The message was clear: support the Jacksons and suffer the consequences. Despite Denise having receipts proving timely payment, the water to their apartment was shut off without warning. When she contacted the utility company, they claimed to have no record of her payment despite the confirmation number on her receipt. It took 3 days and intervention from Shanice Taylor to restore service. Local media finally took interest in the story, but not as expected. The Richmond Daily published an article praising Barrett's vision for urban renewal and job creation, portraying Oakwood Heights residents as obstacles to progress. A quote from an unnamed city official suggested the tenants were exploiting legal technicalities to delay necessary development. The bias was blatant, the developer's influence obvious. City officials who had previously expressed sympathy now avoided Denise's calls. Councilwoman Patricia Davis, who had once promised to look into Barrett's practices, now released a statement about balancing housing needs with economic growth. The political winds had shifted, leaving the Oakwood residents without allies in positions of power. The most disturbing incident came a week after the court hearing. Denise opened their apartment door to find a dead rat placed on the welcome mat, a note pinned to it reading, "Rats should know when to leave." Elijah found his mother sitting on the floor, her back against the wall, staring at the grotesque warning. For the first time, he saw genuine fear in her eyes. "Maybe we should just go," she whispered that night as they ate dinner by candlelight, unable to afford the electric bill after her job losses. "We could stay with Aunt Jasmine until we figure something out. You'd like Baltimore." Elijah pushed his plate away, untouched. "If we leave, Barrett wins. Not just against us, but against everyone at Oakwood. They're counting on us giving up." Denise reached across the table, taking her son's small hands in hers. "I'm so proud of you, Elijah, but I'm scared. These people have shown there's nothing they won't do. My job is to keep you safe." "Running won't keep us safe," Elijah replied, with wisdom beyond his years. "They'll just find someone else to bully, someone who might not be able to fight back like we can." As they sat in the dimming light, weighing impossible choices, Denise realized her son had already made his decision. The question was whether she had the courage to stand alongside him, facing whatever came next. Do you believe Barrett's intimidation tactics would have worked against you? Comment number 1, if you think you would have continued fighting despite the retaliation. Or comment number 2, if you would have protected your family by leaving. Like this video if you admire Elijah's determination to stand up for justice despite overwhelming odds. Subscribe to see how this extraordinary boy builds an alliance strong enough to challenge a corrupt system. How could a 9-year-old possibly overcome such powerful enemies? What alliance could possibly form to support this family against a developer with seemingly unlimited resources and influence? The Richmond Public Library hummed with quiet activity as Elijah Jackson sat at his usual table surrounded by legal texts. His resources had diminished since the apartment break-in, forcing him to rebuild his research from memory and salvaged notes. Absorbed in his work, he didn't notice Miss Proston Rodriguez approaching until she placed a steaming cup of hot chocolate before him. "You look like you could use this," she said, sitting across from him. "Tough week?" Elijah nodded, too exhausted for pretense. "They're trying to scare us away. Mom's thinking about giving up." Miss Rodriguez studied him thoughtfully. "There's someone I think you should meet. He comes in Thursdays to use our legal databases. The following afternoon, she introduced Elijah to Professor Terrence Mitchell from Virginia Commonwealth University Law School. Tall with salt and pepper dreadlocks tied back in a neat ponytail, Mitchell had kind eyes behind wire-rimmed glasses and a reputation for taking on housing rights cases. Miss Savin, on say time. Rodriguez tells me you've been giving Barrett's attorneys a run for their money, he said, reviewing Elijah's reconstituted notes. This is impressive work for anyone, let alone someone your age. When Elijah explained the retaliation they'd faced, Professor Mitchell's expression darkened. Unfortunately, that's their playbook. Intimidate, isolate, overwhelm. But it only works when people fight alone. That evening, Professor Mitchell accompanied Elijah home to meet Denise. Initially skeptical about another potential disappointment, she was disarmed by the professor's straightforward assessment. "What your son accomplished in that courtroom was extraordinary," he told her. "But Barrett has resources you don't. You need a team, not just legal representation." "We can't afford to hire anyone," Denise admitted. "That's why Elijah's been doing this himself." Professor Mitchell smiled. "I teach a clinical practicum on housing discrimination. My students need real-world experience for course credit. If you'll allow us, we'd like to take your case pro bono." For the first time in weeks, hope flickered in Denise's eyes. Meanwhile, Mrs. Coleman had been conducting her own form of resistance. The retired librarian revealed to Elijah that she'd been documenting Barrett's practices for years, maintaining a detailed journal of every interaction, policy change, and maintenance issue at Oakwood Heights since Barrett purchased the property. "I may be old," she told him, displaying notebooks filled with her precise handwriting, "but I know injustice when I see it. I've been waiting for the right moment to share this." Her documentation provided invaluable historical context that strengthened their case considerably. With Professor Mitchell's guidance, Elijah organized a community meeting at Friendship Baptist Church, whose pastor, Reverend Wallace, had been vocal about housing justice. The church basement filled with familiar faces from Oakwood Heights, along with others from different Barrett properties across Richmond. One by one, residents shared similar stories: fabricated lease violations, ignored maintenance requests, intimidation tactics targeting Black and immigrant tenants. The pattern was undeniable and far more widespread than they'd realized. Shanice Taylor arrived with representatives from the Richmond Housing Justice Coalition. "What you're experiencing connects to a larger pattern of displacement happening citywide," she explained, presenting maps showing how development projects consistently pushed out communities of color. "Barrett isn't just building luxury condos, he's systematically whitewashing neighborhoods with generations of Black history." Anthony, the paralegal student who had helped Elijah with his initial research, brought 3 classmates eager to assist. "We've been studying housing discrimination, theoretically," he explained. "This is our chance to fight it in practice." Their technical knowledge and administrative support proved invaluable as the case expanded beyond a single eviction to encompass Barrett's entire business model. Local journalist Maya Chen slipped into the meeting's back row. Earlier, her editor at the Richmond Voice had killed her story about Oakwood Heights after pressure from advertisers. Frustrated, she had taken a leave of absence to pursue the story independently. "I believe this community deserves to have its story told accurately," she told Denise after the meeting. "The mainstream outlets are compromised, but I have contacts at national publications who might be interested." While the core team organized at the church, Anthony made a crucial discovery at the city planning office. Reviewing permit applications for Barrett's properties, he found numerous instances where the developer had falsified information about building occupancy, environmental impacts, and historical preservation requirements. "He's been lying to city officials for years," Anthony reported. "These violations alone could halt construction on all his projects." Professor Mitchell brought additional firepower to their cause. His former colleague, retired Judge Martha Washington, had been the first Black woman appointed to the Richmond Circuit Court before her retirement 5 years earlier. Her reputation for integrity remained unimpeachable. "What you're describing isn't just unethical, it's potentially criminal," she noted after reviewing their evidence. "Fabricating evidence for court proceedings constitutes fraud upon the court." Judge Pearson's failure to disclose his relationship with Barrett violates judicial ethics guidelines. Under her guidance, they prepared a formal complaint to the Virginia Judicial Inquiry and Review Commission. As their alliance grew, Elijah worked with Professor Mitchell to expand their legal strategy beyond a simple eviction defense. "What we're really looking at is a class action lawsuit," Mitchell explained. "Barrett's pattern of discrimination affects dozens, possibly hundreds of tenants. Together they drafted documentation for a Fair Housing Act complaint that would encompass all of Barrett's Richmond properties." Though the break-in had destroyed much of Elijah's original research, the team worked tirelessly to recover and enhance the evidence. Computer science students from VCU restored damaged digital files. Community volunteers conducted new surveys documenting maintenance disparities. Legal aid volunteers finally appeared, apologetic for their earlier inability to help but eager to join the growing movement. Even with growing support, the threats continued. Barrett's security personnel maintained their intimidating presence around Oakwood Heights. Several alliance members reported being followed. Anonymous calls attempted to schedule fake appointments, wasting precious time and resources. But with each obstacle, the community's resolve strengthened. The night before returning to court, Elijah sat at their kitchen table practicing his presentation, while Denise watched with a mixture of pride and anxiety. "Are you sure you want to do this?" she asked. "Barrett's attorneys will be prepared this time. They won't underestimate you again." Elijah looked up from his notes, his young face serious but determined. "They think we're fighting for an apartment, Mom, but we're fighting for something bigger, the right to be treated with dignity, to have our community respected." He gestured to the photos of his father on the wall. "Dad always said that justice doesn't just happen. People have to stand up for it." Denise enveloped her son in a tight embrace, tears streaming down her face. Tomorrow would bring uncertainty and danger, but for the first time since the eviction notice appeared on their door, they wouldn't face it alone. An alliance had formed, unlikely perhaps, but powerful in its diversity and determination. As darkness fell over Richmond, lights burned late in apartments, church offices, and university rooms as dozens of people prepared for the battle ahead. Barrett's money and influence would meet something he hadn't anticipated: a community that refused to be erased. The morning of the rescheduled hearing brought a transformed landscape both inside and outside the Richmond County Courthouse. Where Denise and Elijah had once walked alone up those imposing steps, they now moved at the center of a determined procession. Professor Mitchell and 3 law students flanked them, carrying boxes of evidence and legal briefs. Anthony and his fellow paralegals followed with additional documentation. Mrs. Coleman walked slowly but proudly with her cane, Reverend Wallace supporting her arm. Residents from Oakwood Heights and other Barrett properties formed a protective circle around them. News vans lined the street, alerted by Maya Chen's persistent outreach to national outlets. The courthouse security officers exchanged nervous glances as the group passed through metal detectors and filled the hallway outside courtroom 4B. Inside, Barrett had assembled an even more formidable presence than before. His legal team had doubled in size, now including senior partners from Richmond's most prestigious law firm. City officials, including 2 council members known to be Barrett allies, sat prominently in the gallery. Barrett himself appeared more polished than ever in an expensive suit, projecting confidence as he chatted amiably with his attorneys. Judge Pearson entered, his expression carefully neutral, though his eyes widened slightly at the packed courtroom. "Before we resume Jackson versus Westfield development," he began, "I want to emphasize that this court will maintain strict decorum. Outbursts or demonstrations will not be tolerated." Professor Mitchell rose immediately. "Your Honor, before proceedings continue, we would like to introduce new counsel for the defendants. I am Professor Terrence Mitchell, representing Mrs. Jackson and the additional defendants from Oakwood Heights who have joined this action." He gestured to the law students beside him. "These are licensed legal interns working under my supervision in accordance with Virginia Supreme Court Rule 14b. Judge Pearson frowned. This case has already begun with Mrs. Jackson representing herself. Adding counsel and additional parties at this stage is irregular. "With respect, Your Honor," Mitchell countered, The Virginia Rules of Civil Procedure explicitly permit amendment of proceedings when issues of common fact and law exist. The additional defendants have received identical eviction notices with identical alleged violations. After brief argument, Judge Pearson reluctantly allowed the expanded representation, his discomfort visible. Barrett's lead attorney, now joined by senior partner William Prescott, objected to virtually every document Professor Mitchell attempted to introduce. The judge sustained most objections, creating a record increasingly tilted against the defendants. The breakthrough came 90 minutes into the proceedings when Elijah, who had been quietly conferring with the legal team, passed a note to Professor Mitchell. After reading it, Mitchell stood with renewed purpose. "Your Honor, at this time, we are compelled to introduce evidence of judicial misconduct that directly impacts these proceedings." The courtroom fell silent. Judge Pearson's face reddened. "Counselor, you are treading on dangerous ground. Nevertheless, it is our ethical obligation to proceed," Mitchell replied calmly. "We have documented evidence of financial connections between Your Honor and the plaintiff that constitute a clear conflict of interest requiring recusal." He presented bank records showing transfers from Barrett's company to a consulting firm registered to Judge Pearson's brother-in-law, timed suspiciously close to favorable rulings, in previous cases involving Barrett's properties. Additionally, Mitchell continued, public records indicate Your Honor's ownership interest in the Hillcrest Country Club was subsidized by Mr. Barrett 3 years ago, a financial relationship never disclosed to defendants in this or previous cases. Judge Pearson's knuckles whitened as he gripped his gavel. These allegations are outrageous and irrelevant to the eviction proceedings before us. On the contrary, Mitchell responded, they go directly to the fundamental fairness of these proceedings. We have accordingly filed a formal complaint with the Judicial Inquiry and Review Commission this morning. From the back of the courtroom, a woman in a formal suit stood. Your Honor, I am Regina Washington from the Judicial Review Commission. We have received the complaint and are present to observe these proceedings pursuant to our investigatory authority. Judge Pearson's face drained of color. He had not noticed the commission representative enter. Barrett was now engaged in furious, whispered conversation with his attorneys, his confident facade cracking. Professor Mitchell pressed the advantage. Furthermore, Your Honor, we have evidence that Mr. Barrett's legal team knowingly submitted falsified evidence to this court, which constitutes fraud upon the court. He presented the before and after photos Elijah had salvaged, showing how the apartment damage had been digitally manipulated. A forensic digital analyst from VCU testified to the authenticity of Elijah's findings. Barrett's team objected vehemently, but the evidence was compelling. As the morning progressed, Barrett's attorneys attempted to shift focus through character assassination. Mrs. Jackson's parenting choices raise serious questions, Prescott suggested. Allowing a child to become involved in complex legal matters could be considered a form of exploitation. Professor Mitchell's response was measured, but devastating. My clients have experienced job loss, utilities disconnection, property destruction, and explicit threats since our last court appearance. If counsel wishes to discuss exploitation, perhaps we should address the dead rat left at their door with a threatening note, which police reports confirm was reported last week. The courtroom murmured in shock. Maya Chen's article on the harassment had been published that morning in the Washington Post, copies of which several spectators held. The tide continued to turn when surveillance footage from Oakwood Heights appeared on the courtroom's evidence screen. The timestamps showed Barrett's property manager, Vincent Keller, instructing maintenance staff to ignore requests from certain tenants while expediting others. In another clip, Keller was clearly visible directing someone to place a dead rat at the Jacksons' door. Barrett's legal team scrambled to exclude the footage on procedural grounds, but Judge Pearson, now under observation by the Judicial Commission, reluctantly allowed it. Former Westfield employee Teresa Gonzalez testified about explicit instructions to ignore maintenance requests from black tenants while prioritizing complaints from white residents. Mr. Barrett told us directly that the goal was to make certain residents uncomfortable enough to leave voluntarily, she stated. He called it demographic adjustment and said it was cheaper than formal evictions. Financial documents obtained through subpoena revealed the systematic nature of Barrett's approach. Internal projections showed planned rent increases, specifically calculated to remove lower-income residents after minimal renovations, with marketing materials explicitly targeting upscale professionals described in terms that clearly excluded the current demographic. Throughout the proceedings, Judge Pearson appeared increasingly distressed, especially when the judicial review representative took detailed notes during questionable rulings. His attempts to control the narrative were failing, as national media attention focused on what was becoming a landmark housing discrimination case. The final blow came midway through the afternoon when the courtroom doors opened to admit a distinguished older woman accompanied by two assistants. Retired Judge Martha Washington took a seat in the gallery, her presence immediately recognized by everyone familiar with Richmond's legal community. Judge Pearson's discomfort was palpable as he nodded acknowledgement to his former mentor, known for her uncompromising ethical standards. Minutes later, the judicial review representative approached the bench and handed Judge Pearson an envelope. After reading its contents, his face went ashen. "This court will take a 30-minute recess," he announced abruptly, almost fleeing the courtroom. When proceedings resumed, a court officer made an unexpected announcement. "All rise." The Honorable Judge Amara Johnson presiding. A tall black woman in judicial robes entered, her expression professionally neutral. "Judge Pearson has recused himself from these proceedings," she explained. "The case has been reassigned to me by the Chief Judge. We will resume tomorrow morning at 9 a.m. to ensure all parties have adequate time to prepare." As Barrett and his attorneys conferred in obvious dismay, Elijah leaned toward his mother. "Judge Johnson wrote the majority opinion in Thompson v. Urban Development," he whispered. "She's an expert in housing discrimination law." For the first time since entering the courthouse that morning, Denise allowed herself a small smile. The battle was far from over, but for the first time, they were fighting on level ground. The final day of hearings began with an entirely different atmosphere in courtroom. 3 Amperes, now presided over by Judge Amara Johnson. Her reputation for meticulous fairness and deep knowledge of housing law had preceded her. The gallery overflowed with Oakwood Heights residents, community supporters, and media representatives. National coverage had transformed a local housing dispute into a symbol of the broader struggle against discriminatory development practices. Maxwell Barrett arrived looking noticeably less confident, his legal team having worked through the night to adjust their strategy. During the brief recess before proceedings began, Barrett approached Professor Mitchell in the hallway. "This has gotten out of hand," he said quietly. "We're prepared to offer a settlement. The Jacksons can stay with a new 5-year lease at current rates, plus compensation for their trouble." Professor Mitchell glanced at Denise and Elijah, who had overheard. "And the other residents?" Denise asked. Barrett waved dismissively. "That's a separate matter. This offer is for you specifically." Elijah stepped forward, looking directly at the developer. "Everyone gets treated fairly, or no one accepts your offer," he said simply. Barrett's face hardened. "Don't be foolish. You can't win against my resources." When court resumed, Judge Johnson methodically addressed each aspect of the case, allowing both sides to present evidence without the previous bias. Under her direction, the proceedings focused on documented actions rather than allegations, creating a comprehensive record that couldn't be easily dismissed on appeal. Barrett's team presented character witnesses, city officials, and business leaders who testified to his contributions to Richmond's economy. They argued that development necessarily involved displacement, and that the evictions followed standard business practice rather than discriminatory intent. Professor Mitchell systematically dismantled their defense. Financial experts testified that Barrett's demographic adjustment strategy differed markedly from industry standards, explicitly targeting protected classes of tenants. Housing officials confirmed that the pattern of maintenance neglect violated multiple regulations. Most powerfully, the combined testimonies of Oakwood Heights residents created an undeniable pattern of discriminatory treatment. Throughout the day, settlement offers from Barrett's team grew increasingly generous. The final proposal included allowing all current tenants to remain for 3 years with frozen rent, plus monetary compensation for harassment. "It's a good offer, Professor Mitchell acknowledged during a conference with the Oakwood residents. Many would advise accepting it. Elijah, who had been listening quietly, raised his hand. If we settle, does Mr. Barrett admit he did anything wrong? Mitchell shook his head. Standard settlement language includes no admission of wrongdoing. Then nothing changes, Elijah observed. He just pays us to go away quietly while continuing the same practices elsewhere. The residents ultimately voted unanimously to reject the settlement, choosing instead to pursue a precedent-setting ruling. Judge Johnson's decision came late in the afternoon of the third day. The courtroom fell silent as she began reading from her prepared statement. This court finds overwhelming evidence that Westfield Development engaged in systematic housing discrimination against Black and immigrant tenants at Oakwood Heights and other properties, she stated. The eviction notices are hereby invalidated as products of discriminatory intent and retaliatory action. She ordered Westfield to implement court-supervised maintenance procedures, prohibited any rent increases for existing tenants for 5 years, and awarded substantial damages to each affected household. Most significantly, she referred the evidence of falsified documentation and witness intimidation to the District Attorney's Office for criminal investigation. Mr. Barrett, she concluded, this court is also issuing an injunction freezing all development activities on your Richmond properties pending completion of a full fair housing compliance audit. The courtroom erupted in cheers despite the bailiff's calls for order. Barrett stormed out, refusing to speak to reporters gathered outside. The following weeks brought cascading consequences. The district attorney announced charges against Barrett and Vincent Keller for evidence tampering, witness intimidation, and housing discrimination. Judge Pearson was suspended pending investigation by the Judicial Commission. Denise, whose employment struggles had been highlighted in Maya Chen's nationally syndicated articles, received multiple job offers. She ultimately accepted a position with the Richmond Housing Rights Initiative, where her first-hand experience would help others facing similar situations. The most unexpected development came when Mrs. Fursant Coleman discovered an obscure provision in the original sale of Oakwood Heights to Barrett's company. A clause required any buyer to maintain the property as affordable housing for at least 10 years, or offer current residents first right of purchase if conversion was planned. With legal support from Professor Mitchell's team, the residents formed the Oakwood Heights Housing Cooperative. Using their settlement money as down payment and securing financing through a community development bank, they purchased the property from Barrett's company, which was eager to divest troublesome assets amid mounting legal problems. The school district, embarrassed by national coverage of how Elijah had been treated, implemented a comprehensive gifted program evaluation that identified dozens of overlooked students from disadvantaged backgrounds. Principal Whitmore, whose discouragement of Elijah had been mentioned in several articles, announced his early retirement. Perhaps most significant for the broader community, the City Council passed the Jackson Ordinance, strengthening tenant protections and requiring demographic impact studies before approval of large development projects. The law explicitly prohibited the tactics Barrett had employed and created an independent review board to monitor compliance. On a warm Saturday, 6 months after the final court decision, Elijah and Denise visited Marcus Jackson's grave at the Veterans Cemetery. They placed fresh flowers beside his headstone. "I wish he could see what you did," Denise said softly. "He would be so proud." Elijah traced his father's name on the stone. "I think he knows," he replied. Later that afternoon, they helped the Williams family move into a renovated apartment at the newly established Oakwood Heights Cooperative. Where Barrett had envisioned luxury condominiums for wealthy professionals, a vibrant, diverse community now thrived, collectively owned by its residents. The property manager's office, once Vincent Keller's domain, had been transformed into a legal resource center, offering free advice to tenants throughout Richmond. Posters advertising Know Your Rights workshops decorated the walls, alongside framed newspaper articles chronicling what was now referred to as the Oakwood case. Elijah, now 10 years old, had become a reluctant local celebrity. His experience inspired him to start a youth legal education program, teaching other children about their rights and the power of knowledge. When asked by a reporter if he planned to become a lawyer, his answer was immediate and certain. "A civil rights attorney," he specified. Because laws only protect people when everyone can use them, not just those who can afford expensive lawyers. As the sun set over the renovated community center where Barrett had once planned a residents-only spa, neighbors gathered for a cookout celebrating 1 year since the first eviction notices had appeared. Children played on new playground equipment, while adults shared stories and plans for further improvements to their now resident-owned community. Watching from a bench nearby, Denise put her arm around Elijah's shoulders. "You know what your father always said about justice?" she asked. Elijah nodded, completing the thought they both knew by heart. "It doesn't just happen. People have to stand up for it." Have you ever witnessed a moment when someone unexpected became the catalyst for meaningful change? Share your thoughts in the comments below. If Elijah's courage and intelligence inspired you, please hit the like button to help others discover this story. Subscribe to our channel for more true stories about extraordinary people standing up against injustice and making a difference in their communities. And if you know someone facing housing discrimination or unfair treatment, share this video to remind them that knowledge is power, courage is contagious, and justice is always worth fighting for. Thank you for joining us on this journey from courtroom laughter to community triumph. This story teaches us that knowledge truly is power, especially in the face of systemic injustice. Elijah's journey shows that age, race, and economic status need not determine one's ability to fight for justice. By educating himself and meticulously documenting evidence, a 9-year-old boy was able to challenge a corrupt system designed to silence and displace people who looked like him. The story also highlights the importance of community alliance. While Elijah's individual brilliance sparked the initial resistance, it was the coalition of diverse supporters from academics to journalists, from paralegals to retired judges, that ultimately created the conditions for victory. No matter how right our cause, we rarely win justice battles alone. We learn that systems of power often rely on isolation and intimidation to maintain control. Barrett's tactics, threatening jobs, fabricating evidence, harassing supporters, were designed to break spirits and force compliance. Yet, when people refuse to be silenced, even the most entrenched power structures can be challenged. Perhaps most importantly, the story reminds us that meaningful change requires persistence in the face of overwhelming odds. Each setback the Jacksons faced could have reasonably convinced them to give up, yet they persevered. This teaches us that justice is not an event but a process, one that demands courage, strategic thinking, and unwavering commitment to truth. Real change comes not when we accept injustice as inevitable, but when we decide it is unacceptable. Has there been a moment in your life when you witnessed or experienced injustice, but felt powerless to fight back? What tools or resources might have helped you stand up like Elijah did? Share your thoughts in the comments below. If this story inspired you, please hit that like button to help others discover how one brilliant child fought racial discrimination and won against a corrupt system. Subscribe to our channel for more powerful stories of courage and resilience in the face of injustice. Each subscription helps us continue sharing these important narratives that often go untold. Don't keep this story to yourself. Share it with someone who needs a reminder that knowledge is power and that systems of oppression can be challenged successfully when we work together. Thank you for joining us on this journey from courtroom discrimination to community triumph. Remember, as Elijah's father said, justice doesn't just happen. People have to stand up for it.